नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Until a new domicile has been acquired by me, and by virtue of this new domicile, now I will basically leave the country of origin with an undoubted intention of maybe never returning back. And when I'm referring to these two criteria, I'm re-invoking what I just mentioned, that in order to acquire new domicile, what you must have is that you must be living at a particular place, and then you should have an intention to live there indefinitely or permanently. Now, if this point is understood, that's the first general rule, that everybody will have a domicile. That domicile will continue unless that person changes the domicile by following what I just mentioned. This brings to the second general rule relating to domicile. And that is, a person cannot have two domiciles. A person can have two nationalities, or a person can have citizenship of two countries. But a person will never have two different domiciles. A person can just have one domicile as per law. Now, since the object of the law in say insisting that a person shall not be without a domicile is, say, to establish a definite legal system by which his rights and obligations may be governed. Therefore, it becomes even more imperative, and something which you will all realize by now, that a person cannot hold more than one domicile. A person must have one domicile, only then a definite legal system, a particular legal system can be referred to decide the question of his or her rights and obligations. That's the second point. The third point which I wanted to mention is that the fact that domicile signifies connection with a single system of law, say I am an Indian domicile, therefore domicile signifies the connection with Indian law, my connection with Indian law. It does not necessarily mean that a system that prescribes identical rules for all classes of persons. Now let me explain this point. This point might be a bit tricky here. Just because two people have same domicile of the same country, that does not mean that the same law would apply to the person. Yes, Indian law would apply, if at all law of domicile is the applicable law in the dispute at hand. But that does not necessarily mean that the same law would apply. Imagine that a person is a Christian and a person is a Muslim. They have an Indian domicile, and there is a matrimonial matter before the court. And private international law rule says that law of domicile should apply to solve such an issue. Now, the question which I'm looking at is that just because law of domicile refers to Indian law, does that mean that just one body of law would apply, or identical or similar rules should apply to both the persons? Mere fact that they are Indian domicile, the answer to this question is no. When we are referring to law of domicile, we are broadly referring to the laws of India as a country. And therefore, those laws which are applicable, those specific laws which are applicable to these individuals as Muslims and Christians, and how the personal laws of these two individuals might differ, those laws in force in India would apply to these two individuals. And this is the point which you all must remember. Many people get confused in relation to this point. So this was the third point. The fourth point in relation to, say, identifying general rules of domicile is that there is generally a presumption in favor of continuance of an existing domicile. So if there is a confusion with regard to, say, my domicile of origin and my domicile of choice, then there would be a presumption in favor of continuance of, say, my existing domicile. What if I pass away? And when I passed away, I started living in Canada. And when I was living there in Canada, I'm of course since I'm not there to prove my intention to live there in Canada indefinitely or permanently. Now, when the matter comes before the court, say in relation to some matrimonial matter, where my domicile becomes very important, there would be a presumption in favor of continuance of an existing domicile. Of course, unless that presumption can be defeated. So court will have to be satisfied beyond doubt that when this person moved to Canada, he had the intention of living here indefinitely and he was residing there in Canada. So both the objective test and the subjective test needs to be satisfied. To put a logical corollary of this argument or this point which I mentioned, the fourth point which I mentioned, is that the burden of proving a change in domicile lies in all the cases on those persons who allege that a change has occurred. So just imagine that the question is in relation to certain property issue, movable property issue, and my relatives are basically fighting that when I passed away, who should succeed to the property. Now, if one is able to prove that when I passed away, I had a Canadian domicile, he would benefit. While if the other is able to prove that no, I had an Indian domicile when I passed away, then he would benefit. The burden of proving that a change of domicile has happened is fundamentally on the person who is making that particular argument. So the person who will benefit from the change in domicile, or the person who is arguing that no, this person's domicile has changed, his domicile of origin has changed. Domicile of origin is less controversial because the moment a person is born, domicile of origin is extended to him by virtue of his father, if the child is legitimate. If the child is illegitimate, then mother. Now, at least in law, it is easily identifiable, to put it in simple sense. But where change has occurred, then it is the onus of proving it, or the burden of proving it, is on the person who is making such an argument for change. So these are the four general points relating to domicile which I wanted to mention. Now, an extension of all these arguments would be to study domicile of choice in more detail, because the rules relating to domicile of origin seems to be relatively easily placed. So now we are going to study domicile of choice and see how domicile of choice is understood. Maybe I will revert back to the points which I have already made minutes back, that when it comes to domicile, there are two criteria, there are two requirements. One is that of objective test and the other is that of subjective test. That is residence plus intention. Now, we will come to the first part, that is residence. What do we really mean by it, or a person living there? Now, residence in a country for the purposes of law of domicile implies, say, physical presence in that country, or as an inhabitant of that particular country. So that's the idea of residence that we are talking about, the physical presence in that country as an inhabitant there. Again, residence is regarded as being a question of fact and not as a question of law. So we'll have to establish it as a factual matter, that whether the person had residence in the other country or not. Now, it is important for us to emphasize that residence and intention are interrelated, or maybe to put it in other words, that we cannot completely delineate residence and intention, that residence is a fact, though a necessary one, from which intention may be inferred. So residence can be a ground or can be a basis of inferring the intention as to why this person bought such a big house in Canada. there must be an intention to live there permanently. Or why did this person sell his house in India and then buy the house in Canada? From these factual descriptions, intention can be borrowed. So one cannot completely delineate residence from intention or intention from residence. These are interrelated, though distinct requirements of establishing domicile of choice. Now, there's another issue which has often turned out to be very controversial when it comes to domicile of choice, and that is duration of residence. How much time a person should really live in a country in order to satisfy the objective criteria of residence. Now, this has turned out to be very controversial, so maybe let me reflect on this aspect. That generally length of residence is not exactly specified. So the law does not say that you will have to spend 5 years, 10 years, 15 years to be to satisfy the requirement of objective test. So it is generally said that whatever weight is given to the length of residence, it is undeniable that time is not the sole criterion of domicile. So time is not the only criterion to decide the question of domicile. That's point number one, which we all must remember. While it is an important criteria, it is given some weight in deciding the question of objective of the objective criterion, but it is not the sole criteria. The other factors are also taken into consideration. Long residence does not necessarily constitute domicile, and just because a person had brief residence, that does not mean that the domicile is negated. So it is given some weight. It might be given an important weight. It might be given an important place in deciding the issue of domicile. But it is not the sole criteria. It is not something which will significantly decide whether the person was domiciled there or not. That's the aspect. Oh, can we just enumerate the four rules? And I'll just do that. Let me just go to the end of the lecture and I'll come back to it just for convenience and not for any other reason. I hope that is fine. Yeah, sure. Since I've already missed that message, so it's very difficult to check chat boxes at the same time. Let me open the chat box so that I can follow it closely. Yeah. Yes, all right. So that's one part of it which must be remembered. So duration is not the sole criteria. So in short, residence must be checked both on qualitative level and quantitative level. Meaning thereby that yes, duration might be given some weight. It might be given an important weight. But even the quality of residence, not the quality of house or other things, but in terms of the circumstances surrounding residence is also important. What if a person, let me give you an example. What if a person is ill? A person is not well and he goes to the doctor, and the doctor tells him that, you know what, your problem is that you are living at a very warm place. Maybe you need to go to a colder location. And the person decides to go to hill station. That person goes to hill station just for medical purposes. He has a house there. He goes there. He lives there for 6-7 months, and he's started improving. Mere duration might not be enough. Even the quality and the circumstances surrounding the residence is also important. So the reason as to why the person went there is equally important to understand the question of residence. Therefore, there was this very interesting case called Jopp versus Wood. Now, in this case, it was held that a residence of 25 years in India by a person called John Smith who was a Scottish national, that is not good enough to establish domicile. Just because John Smith lived in India for 25 years, and it was the time when India was colonized, so he came to India as an official of the colonizers, and then he was originally Scottish by birth, and that was not considered as a relevant criteria to decide the issue of domicile. Okay, it's Jopp versus Wood, Jopp versus Wood. This is just to illustrate that. What has happened in the past. So we are going to read the specific cases in this module, but this is just to illustrate that in the past, this is how the questions of domicile has been decided. As I said, maybe I'll be repeating myself again, that brevity of residence is not an obstacle. Just because the residence is short is not an obstacle to the acquisition of a domicile if the necessary intention exists. So if a person is ill and the person goes to a colder location on the advice of the doctor, and after going there, the person says that, you know what, this is the best place to live. I mean, I should spend my entire life here. So just because the person has spent 2 months or 3 months there does not necessarily give him domicile or does not give him domicile. Even the intention would play a very central role. That whether that person changed his mind and said that I'm going to live here indefinitely or permanently, that is the test of intention that we are referring to. That is the test of intention that we have to satisfy. Now, if a man say he clearly intends to live in another country permanently, so for example, where an immigrant, now what an immigrant, for example, does is that he completely winds up his affairs in the country of his origin. He says that, no, I'm going to leave this country permanently. He, whatever money, whatever business he had, he completely, I mean, he wound it up. He sold his house and other property which he had. And then he moves to the next country. His mere arrival there will satisfy the element of residence. Can you get it? This is the kind of quality that we are referring to. The quality that he left everything in the country of origin and then moved to the next country. Then moved to the next country to live there indefinitely. So his arrival there in the country, maybe living there for a week or so, settling himself, even that would be considered as good enough reason to establish that the person had the domicile of that particular country. Even a short residence, a brevity of residence is a good enough reason to establish that the person had domicile. So that's not a restriction. So this is the point which I wanted to make. Now, before we depart and we go to the second test, that is intention test, let me briefly give you an example. Imagine that a man abandoned his home in state, for example, and took his family to a house in state Y, which of course, I mean, so don't understand state in terms of how states are divided on the lines of provinces in India. We are talking about two different countries. That's the vocabulary which international lawyers often use when they refer to the term state. Now, when he moved with his entire family to a new country, he intended there to live there permanently. Now, once he has deposited his belongings there, he and his family say they return to country X in order to spend the night with a relative. So, for example, they are moving from one country to another. They go there, they leave all their properties, they try to settle themselves there. They have deposited all their property in whatever location there is. They have wounded up all their business in the country. But for one night, they return to state X, just to maybe do some trivial thing which might be there, or because they are still trying to settle in the other country and the two countries are not very far off. maybe they're just crossing the border in terms of living there. Change of domicile does not necessarily imply change of nationality. While they might be maintaining the nationality of this country. Now, when they came back to country X for just one night, and they are living with their relative, the person that is, just imagine that the husband, he fell ill and he died there. Now, what would happen to his domicile? What would be his domicile? A person who was living in, say, country X, his domicile of origin was there, but he wounded up his business, he moved to the next country, deposited all his belongings there, came back to country X just to live there for one night to maybe look after some specific issue. Now, in such a situation, his domicile at death was country Y and not country X. Even if he has not lived there, but he has just gone there and settled, and maybe still trying to settle himself, and have returned just because he was not settled in the other country. He has just returned he has just returned to the other country. This is an important part. Right? So these aspects must be taken into consideration to see what was the intention of that particular person, irrespective of the brevity of the duration of the residence. It does not matter whether the person lived there for a long period of time or a short period of time, but whether the both qualitative test and quantitative test is satisfied. The circumstances surrounding the objective test, that is the requirement of residence, is satisfied or not. This is the aspect which I wanted to mention. Now, let me briefly run through the 4 points which one of you asked. When we say general rules of domicile, what I'm referring to is that the first point is that nobody shall be without a domicile. Everybody should have a domicile. I'm just trying to summarize it. The second is that a person cannot have two domiciles. And this is based on the logic that through domicile, we try to identify a definite legal system. And because we try to identify a definite legal system, therefore, if the person has two domiciles, the purpose would be defeated. So that is something which is not allowed. The third point which I wanted to make was that just because two persons have one domicile, that does not mean that the same law would apply to the person. Different laws might apply to the person depending on the specific subject matter. So the example which I gave was that of a Muslim and a Christian having some matrimonial matter before a court. Just because they are both Indian domicile, that does not mean that the same body of law should apply to them. Yes, Indian law might apply, but within Indian law, there are different bodies of law, and different law might apply to the persons that have in terms of solving their matrimonial matters. And the fourth point which I made was that the presumption is in favor of, say, continuance of an existing domicile, and the burden of proving that a change of domicile has taken lies on the party who makes that particular argument. So these are the 4 points. Yes, any questions? Okay, is the domicile of origin of the mother given to child only if she is illegitimate? That's right. Yes, and we will talk about it in detail. I mean, we will try to look at the entire law of domicile in a very critical way as to how problematic the law of domicile is in terms of extending domiciles to children, especially illegitimate children, and that entire classification. Extremely patriarchal, and we will spend at least one full lecture on reading how domicile of dependents really work. And it is in that regard that we will not just look at the domicile of illegitimate children. Tonika, you will be more surprised to see how the domicile of wife is identified. That the domicile of wife immediately changes after marriage, and it takes the form of domicile of husband. So we'll come to this particular point as well. I'm just trying to identify the fund, or maybe lay down the basic rules of domicile. We are going to come to all these points, and you'll find the law of domicile very fascinating and extremely problematic, the way it is placed. ठीक है? Fine, then we meet tomorrow.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।